All right, welcome back to our water fluoridation investigation. So I thought I would pick up where we left off with the cease and desist. But before we jump into that document, I want to update you on a matter that's going on in DeForest, Wisconsin. Okay. Now, I've been following this story for some time, the best of my ability. I've been somewhat distracted with my own documents, so it has been a little bit challenging to know the specifics. But the way I understand it, and forgive me if this isn't exactly correct, but this is kind of the way I understand what's going on. In DeForest, DeForest, Wisconsin, the board voted to get rid of fluoride, right? Hooray, hooray, great job. We have board members with a conscience. So they chose to get rid of the fluoride. Fantastic. Well, some of the board members had a problem with that, and from my understanding, there was another meeting to try to see if they could put it back in the drinking water. And the board, again, the vote was they can't put it back into the drinking water. Now, while all of this is going on, from my understanding, there was some kind of coup to get out one of the board members who was against water fluoridation. And through some sneaky methods, managed to get out that particular board member. And then another board member, if my memory serves me right, who voted against water fluoridation, became unwell and so had to step down from her position. So now you're left with a board that is not complete, right? And there was a problem because you had two of the people who voted against water fluoridation, from my understanding, two of the people who voted against it out, right? And so if they have another vote, then the majority is going to want to put it back in. So a citizen decided that he would file an injunction with the court to prevent the locality from putting fluoride back into the drinking water. Now, I was very eager to know what was going on because I was days away from filing my own injunction, and I wanted to understand what this individual, the argument that he was making, and what the defendant said in response, right? And so I wound up getting in touch with this person, and sure enough, I got a treasure trove of information, and it really helped me a lot to understand the mind of the defendants, being DeForest. What are they going to argue? So then I can preempt a similar situation that Henrico County may engage in. Right. So the information became very valuable for me. And I was very appreciative of this individual who has filed this injunction against the DeForest. Okay. While that was going on, you had these board members that they were chomping at the bit to get fluoride back into the drinking water. And the problem that they had there was essentially that, forgive me, essentially, they had gotten rid of a lot of the equipment when they got rid of fluoride. It was old. It was, as you know, this fluoride, hydrofluorosilicic acid, eats through concrete. It etches glass. It eats through metal. It's very corrosive, right? From my understanding, it's the most dangerous chemical that the waterworks operators have to handle. So they had to figure out, how much is it going to cost to start back up fluoride. And in DeForest, only half of the locality was being fluoridated. So imagine like you have the city of Richmond and only half of Richmond is being fed fluoride, or you have Henrico County and only half of Henrico County has fluoride in the drinking water. And so, from my understanding of listening to the meeting last night, it was because they had essentially taken over another waterworks. And when they did that, they didn't set up fluoride. So the discussion last night was, what is it going to take to get this up and running? And they need to have a dedicated fluoride room. They need to have showers. So if you get it on your skin, you can wash yourself off immediately. Because remember, if you get it on your skin, it will eat straight through your skin and straight through your bones, right? So you have to get this stuff off of you immediately and really flush it out really well. So as they were discussing this, the board members chimed in and said, well, why do you need to have a shower now? Like, you didn't have to have a shower before. Why do you need a shower now? Kind of a stuff. And I couldn't help but laugh. It's scary, but I couldn't help but laugh. Like, they don't understand that when this stuff was put in the drinking water, they didn't care about the welfare of the waterworks operators, right? People view the waterworks operators as disposable men, right? We'll let the men handle these chemicals. We'll let the men have problems with their lungs and their brain and their body. And then when that man's health deteriorates, we'll just replace them with somebody else, right? They're just a body. It's very sickening how they view these waterworks operators as somebody who is just disposable. Who cares if they get harmed? Who cares about their safety? So they couldn't understand that, there were less stringent requirements when the fluoride initially got put into the water versus 2026. They at least say like, hey, if the men get the stuff on their skin, they need to be able to wash it off, right? And it's the way the board came across, they were just trying to figure out how to cut corners. They didn't want to have a dedicated fluoride room. They couldn't comprehend that the off-gassing of the fluoride eats away at the concrete on the walls. It eats away at the concrete on the pipes. And so when you have this stuff in the general area where the other equipment is, it's going to eat away at the other equipment. It's going to be more costly. It's going to be more problematic. It's going to break down. In other words, the board members have no idea what this stuff is. And towards the end of the meeting, they had one board member asked, where does this fluoride come from? And because he said that he's hearing, it's naturally occurring, but then the anti-fluoride group says this is a hazardous waste byproduct. So he asked this gentleman, where does the fluoride come from? I don't know who this gentleman was. I suspect he was a waterworks operator. And he responds by saying he gets it from this company. And I try to find the video, but it's not up yet. I want to say they said Mosaic, but I'm not sure. Anyway, they get it from this company, and he says, like, he doesn't know where it comes from. He just said it's hydrofluorosilicic acid. This is not naturally occurring calcium fluoride that they are grinding up. Okay, that is simply not the truth. And it just highlighted how these board members have no idea what they are doing. And this is reckless endangerment, and I believe it's child abuse, okay? When you are intentionally putting a harmful chemical into the drinking water that causes dental fluorosis, that damages your thyroid, that harms your brain in a similar way to lead, right? It bioaccumulates in your bones, so you're more likely to have fractures and and osteoporosis and a whole litany of problems. They just don't know what's going on. So anyway, there was quite a bit of people who spoke, and the person who spoke last, I thought would persuade them, right? But I was wrong. They voted in order to keep to put the fluoride back into the drinking water. So we're going to keep an eye on what's going on in DeForest, Wisconsin, and we're going to follow the court filings that may arise after this. So with that being said, I think it is time to get into our cease and desist here in Henrico County. When the DeForest, Wisconsin video becomes available, I plan on posting it because there's not very many situations where you get to hear the men describe how corrosive and dangerous this chemical really is, and how much PPE you need, and there was a lot of things that was said back and forth that I think is important for the public to hear if you are not familiar with this topic. So anyway, let me stop talking and get into our document, which is the cease and desist. So here we go. Okay, guys, so we left off on page 13. Let's start into improper reliance on administrative permit. This is going to be very important because I think this is how Henrico County is going to try to defend themselves. Henrico County appears to be relying on a waterworks permit issued by the Virginia Department of Health as authority for adding fluoride to the public drinking water supply. That reliance is legally misplaced. An administrative permit cannot create authority where none exist. VDH as a regulatory agency possesses only those powers expressly granted by the Virginia General Assembly. While it may regulate the manner in which an activity is conducted, it cannot authorize the activity itself absent clear statutory delegation. The inclusion of fluoridation provisions in a Virginia Department of Health permit is therefore not a lawful source of authority. The depositive question is whether the Virginia General Assembly has affirmatively authorized localities to add fluoride to public drinking water. Absent such authority, the practice exceeds the lawful powers of both VDH and Henrico County under both the Code of Virginia and Dillon's Rule. Okay, this is very important. VDH has exceeded its authority by holding itself out as having the power to authorize water fluoridation in Henrico through the issuance of a so-called fluoride permit. This permit is the central nexus of the legal defect, as it is used to create the appearance of authority where none exist. Henrico County believes that because VDH gave them a permit to put fluoride equipment at their waterworks, magically that makes it legal. It does not. That is what I'm arguing. That is the controversy. All right, let's move on. When asked to identify the legal basis for fluoridation, waterworks operators, the DPU director, and FOIA responses consistently cite only the VDH waterworks permit, not any statute, demonstrating a systemic conflation of administrative oversight with legislative authorization. VDH's historical disclaimers of liability further underscore that the agency has acted only in an advisory capacity and is not a source of independent legal authority. Henrico received bad advice from VDH and must cut their losses immediately. This is what I'm telling Henrico to do. You guys need to stop. Just cut your losses and cut it out. They didn't want it in the water anyway, which is why they took it out for a year until VDH allegedly tricked them into putting it back in. Moreover, VDH has repeatedly stated that it never authorized nor required Henrico to fluoridate the drinking water. They themselves assert that the fluoride permit does not confer any legal authority to put the FDA-defined drug in the water. The agency claims no responsibility for any of Henrico's unlawful actions. So VDH, this is important. VDH does not assert that when they gave Henrico a permit to put fluoride equipment in their waterworks, VDH doesn't claim that that gave Henrico the legal authority to put fluoride in the drinking water. That is very important. All right. Unquestionably, any advice, endorsement, recommendation, or guidance from VDH cannot substitute for statutory authorization. VDH seems to recognize this most basic fact, but the County of Henrico does not, right? VDH has repeatedly acknowledged that a fluoride permit alone does not create or confer legal authority for a locality to add fluoride. Any such authority must come from the Virginia General Assembly, not from administrative permits or agency guidance. VDH has further asserted that it's not their fault if Henrico is illegally adding fluoride to the public drinking water without proper legislative backing, consistently claiming that it is the county's responsibility to ensure the addition of this FDA-defined drug going into the public drinking water complies with current law and ethics. This leaves Henrico holding the bag, right? VDH does not support Henrico in their claim of, well, we have a permit, so therefore we can do whatever we want. VDH does not support that. All right. It is astonishing and legally indefensible that VDH has advised Henrico County to add fluoride to the water and issue these so-called fluoride permits despite the absence of statutory authority. This guidance encourages ultra-vires conduct and exposes both residents and the county to unnecessary risks. With VDH disclaiming liability, Henrico alone bears the financial and physical consequences of any resulting harm. Remember, VDH recommends this, which is why Henrico was confused that what they're doing is problematic. They think, well, why would VDH recommend something that we don't actually have the legal authority to do, right? So, but VDH's position is like, hey, we can't help if you followed our recommendations that aren't supported by state law or an ordinance or, I don't know, common sense, logic, reason, ethics, informed consent, constitutional backings. Like, it's, our health department is extremely corrupt, in my opinion. During a visit to the Library of Virginia, I located official records that directly address the legality of water fluoridation in the Commonwealth. These records establish that the Virginia Department of Health was fully aware that it lacked statutory authority under the public water supply law, not only to require fluoridation, but to regulate it at all. The board expressly acknowledged this limitation. As reflected in the record, the board then discussed the question. So this is the meeting minute. So as reflected in the record, this is the quote. This is what VDH said in their meeting minutes. The board then discussed the question of fluoridation of water supplies in line with its previous request that this be made a part of the regulations. Mr. Adams stated that under the public water supply law, fluoridation of the water supplies could not be made a requirement, right? They acknowledge that VDH does not have the legal authority to require this, and that's what they wanted to do. What did they proceed to do after that? They proceeded to sneak in a regulation that says the board may require water fluoridation. Okay, so this is an admission that they knew what they were doing was not on the up and up, in my opinion. May 2nd, 1973, VDH voted to require fluoride. May 7th, 1974, VDH stated that under the public water supply law, fluoridation of the water supplies could not be made a requirement. 1974, Waterworks regulations. Now, this is important. This is from the meeting minutes. Fluoridation, where practical and feasible, the board may require owners of waterworks to provide artificial fluoridation so as to bring the fluoride ion concentration to the optimal level as set forth in section 4.0. What? Why are they doing that? May require, when they know they're not supposed to require this, right? This is problematic. The previous meeting minutes, they acknowledge that you cannot require water fluoridation. All right, let's move on. 2021 Waterworks Regulations 12 VAC 5-590-930 fluoridation. The board recommends that all community waterworks in Virginia be optimally fluoridated. Fluoridation feed systems shall be designed to deliver the optimal fluoride ion concentration as determined by the United States Department of Health and Human Services. Health and Human Services does not set an optimal ion concentration. It is the Public Health Service, and that was back in 2015. So technically, this is not correct. I understand that the Public Health Service is under HHS, but to me, I think it matters that this says HHS. We know Kennedy is against water fluoridation. So if you want to go with HHS, Kennedy says don't do it, right? So I don't know. I have a problem with this. Other people don't seem to think that this is a big deal. I think this is a big deal. September 23rd, 1973. Okay. So in 2021, essentially, they changed the language from the board may require water fluoridation to the board recommends water fluoridation. I would imagine that they wanted to change the language to recommend because they were following the lawsuit against the EPA and they wanted to distance themselves from this fluoride scheme, if I were to be a guessing person. All right, let's move on to September 23rd, 1973, Richmond Times-Dispatch, page 11. What happened was they omitted the fluoride regulation. Richmond Times-Dispatch, March 4th, 1974, page 13. They omitted the fluoride regulation. That's a problem, okay? So when they put up the notice that they were going to make waterworks regulations, what Richmond Times-Dispatch did was they said that there was going to be regulations to promote pure water. They never told the public that they were going to sneak in this fluoride regulation. So procedurally, I think that this regulation should be void based on two reasons. One, I don't believe they have the statutory backing based on the language of the law. And two, procedurally, you have to allow the public an opportunity to give their 2 cents about it, essentially. Okay, so right here we have the meeting minutes that we've already went through, I think. Let's see. The board then discussed the question of fluoridation of water supplies in line with its previous request that this be made a part of the regulation. Okay, so remember, they want to put in this, the board may require water fluoridation, so they're bringing it back up. And Mr. Adams stated that under the public water supply law, fluoridation of the water supplies could not be made a requirement, but that it might be covered under general health laws. It was not. Dr. Shanholtz stated that Virginia was a leader in the fluoridation of public water supplies, with approximately 3.7 million of its 4.4 million population drinking from a fluoridated supply. So essentially what happened was you had 1973, 74, you had the Safe Drinking Water Act, where the federal government said the feds cannot require water fluoridation. And VDH was required to write up regulations that was in compliance with the Federal Safe Drinking Water Act. Now, the Federal Safe Drinking Water Act says that Virginia cannot be any less stringent, right? VDH, as the primacy agency, cannot be less stringent than the federal government. In other words, if you have a primary drinking water regulation that has a maximum contaminant level of 4 parts per million, VDH has to at least say 4 parts per million is the maximum contaminant level. But VDH can also be more stringent and said, no, we think the maximum contaminant level should be 0.15 parts per million, right? So you can be more stringent. You just can't be less stringent. Now, one individual made the argument that if the federal government is forbidden from requiring water fluoridation, then VDH being less stringent, they're allowing localities to put fluoride in the drinking water, right? So they're being less stringent than the feds. I'm going to have to go back and look at the Federal Safe Drinking Water Act to see what the specific language is. I think what they're doing is playing a linguistic game, but I'll have to look at that because sure enough, I mean, in the Federal Safe Drinking Water Act, it says that the feds cannot require water fluoridation, and if the primacy agency can't be less stringent, then why are they putting fluoride in the drinking water? I'm going to have to look at that because it may be just in regards to the primary drinking water regulations, such as like there's a maximum contaminant level for mercury, lead, arsenic. So it could be just in regards to that, but I'll have to take a look. I was reading something about that this morning, and I'm not sure if that are. I understand where the individual's coming from. I'm just not sure if technically they're correct. So we'll have to look at that. All right, let's get into page 16. Mr. Adams speculated about how they may be able to slide this fluoride regulation in under the general health laws, but the record does not appear to reflect that such action took effect. The board backtracked from their initial vote on May 2nd, 1973, when they first discussed submerging the fluoride regulation within the trove of waterworks regulations that they created to comply with the Federal Safe Drinking Water Act, an act that forbade the federal government from requiring water fluoridation. Okay, I kind of forgot that I put this in here. So let's see what the language is. It says, so this is 1974 Waterworks, the Safe Drinking Water Act. It says the administrator under this section would be prohibited from requiring the addition of any substance other than for the purpose of treating contaminants. Thus, EPA could not require the addition of fluorides or other substances to a public water system for medical purposes, nor could EPA prevent the addition of fluorides or other substances up to the maximum amount allowable under a maximum contaminant level. Well, there you have it. So the administrator is forbidden from requiring water fluoridation, but they make it clear that they are not preventing localities from having fluoride in the drinking water up to the maximum contaminant level. Okay, so I kind of felt like the gentleman's argument wouldn't stand up to scrutiny, and I was correct. It's disappointing, but that's the way the cookie crumbles. What's unique about this, well, not unique, interesting, I would say, is notice how nobody wants to take responsibility for this chemical drug in drinking water. EPA does not want to take responsibility. They say, my name's Bennett and I ain't in it. And then you have VDH, they don't want to take responsibility for this either. And for more than a year and a half, I've been asking Henrico County who was responsible for the fluoride in the drinking water, who made the decision to add it back in. Initially, the DPU director, Bentley Chan, said he was responsible, but then when I gave a speech, he then changed his mind and wanted to backtrack out of that. The county manager at another meeting, he said, if it's the devil you seek, then name my name. I don't know if that's taking responsibility or not. Nobody wants to stand up and say, hey, I'm responsible for the chemical drug in the drinking water. If it's so fabulous, why are they so afraid of taking ownership of it, right? It's because it's not. Okay, so this essentially, let me reread this so we can understand the full breadth of this paragraph. It says the administrator under this section would be prohibited from requiring the addition of any substance other than for the purpose of treating contaminants. Thus, EPA could not require the addition of fluorides or other substances to a public water system for medical purposes, nor could EPA prevent the addition of fluorides or other substances up to the maximum amount allowable under a maximum contaminant level. So technically, for example, okay, there's a maximum contaminant level for fluoride. So this is saying that the localities can intentionally add fluoride up to 4 parts per million. Whatever, I don't know what the maximum contaminant level of lead is, but this is saying that the EPA cannot prevent a locality from intentionally adding lead into the water. The EPA cannot prevent the deliberate addition of mercury. The EPA cannot prevent the deliberate addition of arsenic or cadmium or aluminum. To say that nor could EPA prevent the addition of fluorides or other substances. So you can add whatever you want. The locality can intentionally contaminate the drinking water with heavy metals as intentionally. It just needs to be under the maximum contaminant level. I mean, this sounds like psychopaths to me, in my opinion. But nonetheless, that is the language. So congratulations, go out and purchase lead and arsenic and mercury and cadmium and plutonium and, God knows what else, and intentionally add it to the drinking water. Just keep it right under the maximum contaminant level, would you? Gosh, these people are monsters. Okay, while EPA could not require the addition of a substance, while the EPA could not require the addition of a substance for medical purposes, the agency would have full authority to limit the addition of a substance of such a substance if necessary to prevent excessive levels from occurring or to prevent such substance from interfering with the effectiveness of any required treatment techniques. What? While EPA could not require the addition of substance for medical purposes, the agency would have full authority to limit the addition of such a substance if necessary to prevent excessive levels from occurring or to prevent such substance from interfering with the effectiveness of any required treatment techniques. Okay, so if they can interfere when it's over 4 parts per million, and then they can interfere if, like, fluoride is interfering with another chemical that's required to treat the water to make it safe to drink. Okay, so they can't have negative interactions with one another. Well, that's exactly what happens, because the fluoride is acidic, and so it interferes with the water, and then they wind up having to put some type of, like, conditioner into the water to make the water less acidic. So technically this is interfering with stuff. You add a chemical, fluoride, and then you have to add another chemical in order to deal with that chemical. So this is, you're chasing the dragon. Okay, let's move on. Page 17. So this is meeting minutes, Virginia Department of Health meeting minutes. This is May 2nd, 1973. So remember, what's going on is VDH, they are required to write up a bunch of waterworks regulations in order to be in compliance with the Federal Safe Drinking Water Act. So they understand that the feds, they don't want to require, recommend. EPA does not recommend water fluoridation. EPA does not require water fluoridation. And so they don't want to take responsibility, because they understand that this chemical, it has been traditionally used to make animals permanently go to sleep. So they don't want to, they know that eventually it's going to come back, in my opinion. Well, and actually, that's not really in my opinion. I've been reading what the EPA individuals had to say, and they did not support it. They were very much against it, and they actually wound up suing the EPA because, so they sued their bosses in order to try to prevent the fluoride from being added into their water, and they wound up failing. All right, so let's get back to the meeting minutes. This is 1973. The Safe Drinking Water Act is getting ready to come on the scene. So it says, Mr. Adams reported that his staff was drawing up proposed rules and regulations for public water supplies, which he felt were necessary because of the rapidly expanded number of supplies in the state and potable action by Congress in passing the Pure Drinking Water Law. They're talking about the Safe Drinking Water Act. It now appears that a federal act will be approved by July 1st, 1973, which will include primary drinking water standards for medical reasons and secondary standards for aesthetic reasons. The law will provide for state enforcement, and the state must adopt regulations which are equally as stringent as the federal regulation. That's actually not correct. Not equally stringent. You can't be any less stringent. So you can be stricter and, say we want 0 mercury, lead, arsenic in the water, but you can't go above the maximum contaminant level. Okay, so adopt regulations which are equally as stringent as the federal regulations. It is possible that federal funds will be appropriated. Mr. Adams stated that the proposed rules and regulations were nearing final draft stage and were being reviewed by the Attorney General's office in the hope that they could be presented to the Board of Health in September. And so they're discussing how they need to get in line with the Federal Safe Drinking Water Act. And then on the very next paragraph, look what they try to do. They say, on motion by Mr. Haggerty. Now, he's a dentist. He was friends with the governor, the attorney general. He was part of the Republican Party. The Republican Party loved him and backed him. So he's got a lot of clout. So on motion made by Mr. Haggerty, or Dr. Haggerty, the dentist, who everybody, supports, seconded by Dr. Hutchinson, the board instructed Mr. Adams to include in the regulations a requirement that fluoride be introduced into the public water supply at approved level, if not otherwise available in the natural supply. This being a method for the control of dental disease accepted by all national dental organizations. So here's what's going on. We've got 1973, and they realize they've got a situation because since 1952, they've been allowing localities to put fluoride in the drinking water. Remember, at this point in 1973, we have a situation where 3.9 million Virginians are ingesting fluoridated water out of, what was it, like 4.1, right? I mean, that's nearly all Virginians are ingesting fluoridated water. And they realized that these localities don't have the authority to do so. There's no state law that authorizes it. As you recall, previously, they tried to pass a state law, but Virginia legislators rejected it and instead stuck with pure water. So I believe what they were doing here is trying to cover their skin. They realized they messed up. They allowed localities to do this and that they didn't have the legal authority to do so. So they thought, well, let me sneak it into this huge all of these waterworks regulations, right? It was a mountain of waterworks regulations. If we sneak in this one about fluoride, nobody will ever know. And because these waterworks regulations are coming on the scene at the demand of the Federal Safe Drinking Water Act, localities, the waterworks operators, the DPU director will assume that if it's in the waterworks regulations, then it must be a requirement under the Federal Safe Drinking Water Act. It is very deceitful and manipulative, and in my opinion, the entire situation is unlawful. But that's what we're going to have a judge figure out. That is the controversy. Okay, so let's move on. Here are links to the Richmond Times-Dispatch. Let's see if I put yes. Okay. So the law says that if you're going to put in these waterworks regulations, then you have to put a notice in the paper, a public notice. So the public has an opportunity to come out and support the waterworks regulations or to oppose waterworks regulations, right? And the notice must be written in a way where people understand what's going on. So what we're going to be looking for in this public notice that was in the Richmond Times-Dispatch, in what year are we working on? 1973 and 1974. Let's see if Virginia Department of Health let the public know that they're going to be inserting or creating a waterworks regulation that says that the board may require water fluoridation, despite VDH already admitting and recognizing that they don't have the statutory backing. So let's look here. Did VDH say in this newsletter, in this public notice, that they were going to be making a waterworks regulation to require water fluoridation? Remember, they use the word may require water fluoridation, right? That may word is very important. It's to manipulate the localities. because they know they cannot legally require it. So what they do is say, oh, well, we may require it. Well, no, you can't. Okay, so this is very, very problematic in my opinion. Okay, Commonwealth of Virginia State Board of Health, legal notice of public hearing on public water supplies. Let's see if the other one is a little clearer. It is. It's pretty much the same. And we've gone over this before. So it says, pursuant to the authority vested in the State Board of Health by Title 62.1, Chapter 4, Section 62.1-46, and in accordance with the Title 9, Chapter 1.1 Code of Virginia as amended in 1950, notice is hereby given of a public hearing by the State Board of Health to be upheld on Wednesday, April 3rd, 1974 at 2 p.m. in the building, okay, such and such, such and such. It says that the said hearing shall consider adoption of rules and regulations of the Board of Health, Commonwealth of Virginia, governing waterworks, water supplies, and pure water within the Commonwealth. Does it say that they're going to be governing a chemical drug? No. Pure water means you remove contaminants from the drinking water. So again, VDH has a problem, in my opinion, because they know they don't have the statutory backing, and then they did not send out a public notice, so the public had a chance to oppose this waterworks regulation regarding water fluoridation. They go on to say that the regulations set forth general provisions for obtaining and revoking permits to construct and operate waterworks, establish general criteria for the operation of waterworks, establish criteria for bacteriological, chemical quality for pure water, set forth procedures for elimination and control of cross-contamination, establish the general design and construction requirements. Okay, so it's to the water. They're claiming that the regulations is about making sure we have pure water to be in line with the Federal Safe Drinking Water Act. That is what was supposed to happen, right? And they didn't let the public know that if water fluoridation is so fabulous, why didn't they let the public know? It's because at this point, like I said, they had tried to pass a law in Virginia to require water fluoridation, and the legislators rejected it. The governor rejected water fluoridation. The president at the time rejected water fluoridation. People were coming out all over rejecting water fluoridation because it's used to unalive undesirable things, okay? So they don't want this in the drinking water. They know fluoride overflows occur. Richmond had more than a month's worth of fluoride go into the drinking water in 5 hours and 15 minutes. Lord knows, how many people that harmed, or, possibly people may have gone to sleep permanently because of that. All right, let's see. We've got, I think we're going to kind of wrap this up shortly. We'll do this next section. So we're at page 20, unlawful promulgation of regulations in violation of statutory notice and due process requirements. So we're going into exactly what I'm talking about. The public was deprived of a meaningful opportunity to object to the fluoridation regulations adopted in 1973-74. In violation of statutory notice requirements and procedural due process under Title 9, Chapter 1.1 Code of Virginia as amended in 1950. They were deprived of a meaningful opportunity to object fluoridation. This is outrageous. The published notice in the Richmond Times-Dispatch described the proposed regulations as relating to pure water, with no reference to fluoride, fluoridation, or any form of medical or preventive treatment. As a result, the notice failed to disclose the true nature and substance of the proposed rule as it related to water fluoridation. Under 9-6.4, agencies are required to publish either the express terms or an informative summary of a proposed rule prior to adoption. They did not do that. Additionally, 9-6.1 guarantees all interested persons the opportunity to be heard and to submit objections, evidence, and argument. By failing to disclose that fluoridation would be included within the proposed regulations, the agency did not provide adequate notice sufficient to inform the public of the rule's actual scope and effect. This defect rendered the statutory opportunity to be heard illusionary. Right? And you should look up what that word illusionary means, because it's exactly what took place. This is exactly what took place. It is illusionary. The public might have technically been given notice or a time to speak, but the process was so flawed, e.g., lack of adequate information, that the public could not adequately defend their rights. And I will say this again, it was illusionary, meaning the public might have technically been given a notice or a time to speak, but the process was so flawed, lack of adequate information, right? They didn't mention anything about fluoride, that the public could not adequately defend their rights. This is outrageous. And yet, Henrico County would like to continue with this. The fact that VDH had to stoop to this level to put in the regulation to me is an admission of guilt. I get the impression that they know what they're doing is wrong, that they know what they've done is wrong, and that for whatever reason, they don't want to back out of this. All right, let's move on. How could the public have known to object to the unlawful fluoridation regulation when they were never given a notice? The legal notice of public hearing for public water supply was never mentioned that the state health department was attempting to circumvent the Virginia legislature by implementing an unlawful regulation that would have encouraged localities to commit an ultra-vires act by mass medicating the public with various clandestine operations, such as the one that the county of Henrico is currently engaging in today. And I do call this a clandestine operation because Henrico County is putting this in the drinking water, and the only way that you will know if it's in the drinking water is if you do a Freedom of Information Act request for the monthly operating reports. How many citizens in Henrico County know what a Freedom of Information Act request is? How many citizens in Henrico know what a monthly operating report is? How many citizens would know how to read the information, interpret the data? They are not doing this in a transparent way, which to me, anytime you are trying to hide like this, it makes you look guilty. It makes you look like a bad person, in my opinion. Okay? All of this information is in my opinion. I am allowed to have an opinion about my government and what they are doing and the drugs that they are putting in the drinking water. Accordingly, the adoption of the fluoridation provision was procedurally defective and deprived the public of its right to participate in the rulemaking process, in violation of both statutory requirements and fundamental principles of procedural due process. The lack of statutory authority for the fluoridation regulation, as well as the lack of public notice to the public of said notice, is a clear deprivation of rights that should be rights. I'll correct well, I guess I can't correct this because this is the document that I sent to Henrico, so I've got to leave that error. forgive me guys, the lack of statutory authority for the fluoridation regulation, as well as the lack of notice to the public of said notice, is a clear deprivation of rights under the color of law. In other words, what they're doing, acting under the color of law, means that you are behaving in a way that as if that you have the legal authority when you do not, right? So if a police officer, for example, if you're walking down the road, you're not doing anything, let's say you're walking down the sidewalk and you're not doing anything wrong, you're minding your own business, the police officer cannot just walk over to you and say, give me your ID, right? They have to have reasonable, articulable suspicion that you had committed a crime, you are committing a crime, or you're about to commit a crime. And absent any RAS, they cannot force you to show your ID. Now, there are officers who are mistaken and think that they can just compel ID. And when they do that, they are acting under the color of law. They are acting as if they have the legal authority to stop an ID any Tom, Dick, and Harry for whatever reason that they please. And that is not how it works in America. You have to have the legal authority in order to be engaging in such conduct. And so when I'm saying that Henrico County and VDH are acting under the color of law, they're acting as if there is a law that allows them to do what they're doing. And I am arguing that they do not, right? That is the argument that I have put together. I do not believe that it is lawful to compel 2-year-olds to ingest fluoride, right? A doctor, right now, if a mother wanted to get a prescription for fluoride and give fluoride to their 2-year-old, a doctor cannot legally write a prescription as it stands right now. The FDA says doctors are forbidden from writing prescriptions for fluoride for children under the age of 3. Now, Henrico County, the fact that they are putting fluoride in the drinking water, they are giving children under the age of 3 fluoride. So they circumvent the issue. And the reason why we're in this situation is because, in my opinion, the FDA has been derelict in their duties. The FDA chose to say, well, we're not going to regulate the fluoride in the public drinking water. They'll regulate fluoride drops and fluoride tablets. They'll regulate fluoride in bottled water, but they refuse to take responsibility for the fluoride in the water works. Again, the theme is that the FDA does not want responsibility for community water fluoridation. Virginia Department of Health does not take responsibility for water fluoridation. The EPA does not take responsibility for water fluoridation, and there currently is nobody in the county of Henrico who's willing to take responsibility for water fluoridation. I would argue that what these localities are doing is circumventing doctors and circumventing mothers, because imagine, you cannot have the board of supervisors on the street handing out fluoride drops or fluoride tablets. They would be practicing medicine at a law, practicing medicine without a license. And so because our government is corrupt, they're allowed to put the chemical drug in the public drinking water using the waterworks as a mechanism. And so that's what they're going to do. Because they're forbidden from giving out fluoride drops and fluoride tablets to children, on the street, they say, well, don't worry, I know how to get around this. Ha ha ha, we're going to put it in your public drinking water. Who cares if we can't give it to you on the street? We'll just add some into your water, into your public drinking water. Does that sound ethical to you? Does that sound lawful to you? No, it does not. It sounds like monsters, in my opinion. Okay, I think we're going to wrap this up in a minute. We've got the 1964 Code of Virginia. So this is what has to do with the public hearings. And it says we have 9-6.6 public hearings on proposed rules, adoptions, and amendments. So this is what VDH was required to do under the law. A public hearing shall be held by the agency at the time and place named in the notice required, and opportunity shall be afforded all interested parties to be heard and to submit objections, amendments, evidence, and arguments. So because the VDH did not tell the public that fluoride, they were going to put in this fluoride regulation, the public did not have the opportunity to be heard about water fluoridation. They did not have the opportunity to submit objections, amendments, evidence, and arguments. Okay? This is blatantly corrupt. The rule may be adopted in the form in which it was filed or as amended at the hearing, provided the amendments do not alter the main purpose of the rule. I can tell that there was a problem. What I did was copied it from the picture that I took of the code when I was at the Library of Virginia. So we'll just have to leave that error. 9-6.8 petition for promulgation, amended or repeal of rule. Any interested person may petition an agency requesting the promulgation, amendment, or repeal of any rule. Notice how it says repeal. The way that the law says now, you can't repeal it. You can only just amend it. I suppose you can amend it to say that water fluoridation is forbidden. So ridiculous. These people are so corrupt, in my opinion. Rule means any regulation, including amendments and repeals of general application and further affecting private rights, privileges, or interests promulgated by any agency to implement, extend, apply, interpret, or make specific the legislation, enforcement, or administered by it. Does not include regulations solely concerning internal management of the agency or of the state government, nor regulations of which notice is customarily given to the public only by makers or signs, nor mere instructions. Okay, so essentially a rule means that this is a regulation. That was kind of a lengthy way of getting to that point for you guys. 9-6.4 publication and filings of proposed rules. No rule shall hereafter be promulgated by any agency unless and until the express terms or an informative summary. So, was there an informative summary? Did they mention water fluoridation in that Richmond Times-Dispatch article? No. So, I would argue that they violated state law. Of the proposed rule has been published by and all the expense of the agency at least once in at least one newspaper of general circulation published in Richmond, Virginia. So they put it in the Richmond Times-Dispatch. Or if the rule has only local application in the locality to which it applies, and a copy has been filed in the office of the Division of Statutory Research and Drafting, where it shall be subject to inspection during office hours by any person. Such publication and filing must be not less than 15 nor more than 30 days prior to the day on which the public hearing on the proposal is to be held. The published notice shall include a statement of time, place, and nature of the hearing. Nature of the hearing. Did they talk about water fluoridation? No. Of the hearing, an exact reference to the authority under which the rule is proposed. In other words, you have to have statutory backing. They don't have statutory backing. What they point to is a law that requires pure water. And the clear intent of the law explains that the purpose is to remove contaminations from the water to make it safe to drink. So I believe that's why they did not let the public know, is because they knew they did not have the statutory backing. They knew that somebody was going to pick up on this. And so they chose not to post it in the Richmond Times-Dispatch to let the people know what they were up to, and they snuck it in under the other waterworks regulations that was required by the Federal Safe Drinking Water Act, and they passed it off as if this was anointed by the federal government and that water fluoridation may be required. And that allegedly VDH, the localities I've spoken to said VDH did force them to put fluoride in the drinking water. VDH did require them to do it. But then when I asked for documents to support that assertion, the localities do not have documents to support that claim. So it seems like what this was being done was they were being verbally manipulated, allegedly. I mean, that's the claim. I've had many waterworks tell me this in Virginia, that VDH forced them. I follow it up, provide me the documents to support that claim. They don't have anything. I've confronted VDH and they say, I don't know why. We may have used suggestive language that it's required, but we didn't technically force them into it. So the whole thing was done in a very slimy way, allegedly. All right, so we've got the public hearing and proposed rules. So I think we just read that. So we can move on. Petition, yes, we've gone through that. So that's 1974, rule for advertising in the Richmond Times-Dispatch. Okay, you don't have to advertise it in the Richmond Times-Dispatch, but that's what they did. They put it in the Richmond Times-Dispatch rule. So this is just photographs of the Code of Virginia. So let's see. Should we leave it? Should we end? I guess we could. I guess this is a good place to end, guys. And then we will pick up next on these waterworks regulations by secretly adding the fluoridation regulations. I don't know. I kind of hate to stop. We're kind of stopping halfway through a chapter. So I don't know. Let's continue, guys. Hang in there, okay? And then we'll wrap up this section. Just because I don't want to stop like halfway through this point that I'm making. So it says, by secretly adding the fluoridation regulations inside the waterworks regulations meant that fluoridation in some localities has solely been implemented on an administrative level. They don't even pretend as if this is being done on a legislative level, such as Henrico, right? They don't have anything. It's solely being done on an administrative level instead of the legislative level, thereby leaving many mayors, county managers, city council leaders, and the board of supervisors completely in the dark. Right? Because they didn't even realize. They thought if it's in the waterworks regulations, they gotta do it. And so the waterworks operators were just doing it. The DPU director was just doing it. And in many cases, the county manager had no idea. They just trusted that the waterworks operators knew how to legally interpret waterworks regulations. Gosh, it's so sloppy, guys. This process is so sloppy. The Board of Supervisors, they had no idea. They just thought, waterworks regulations and DPU director, they know how to understand the law. They know how to understand the administrative code. No, actually, they don't. Virginia Department of Health used the Safe Drinking Water Act and Virginia Waterworks regulations as a Trojan horse to usher in this ultra-virus fluoride regulation. Mr. Adams pointed out that they did not have the statutory authority, which is why they reworked the language that would still suit their agenda. The sketchiness of the regulation is likely the reason why they never put a notice in the newspaper to receive public comment. Instead, they told the public that the waterworks regulations were about pure water. Despite the clear admission that under the public water supply law, fluoridation of the water supplies could not be made a requirement, VDH proceeded to incorporate fluoridation into its regulatory framework on May 7th, 1974. This is the Waterworks regulations from May 7th, 1974. This was very difficult to locate, guys. Very difficult. I wound up having to seek help from some higher ups. Okay, so here is what they put in. Remember, they now have for the first time this massive book of waterworks regulation, and so they just put it right on in, and the waterworks operators in Virginia thought, well, if it's in the manual, we got to do it. If it's a waterworks regulation, we got to do it. When it says the board may require owners of waterworks to put fluoride in the drinking water, they thought VDH could legally force them. VDH says, no, sure, we put in may require, but we knew we could never require them. And by the way, there's no paper trail showing that we ever forced them into it. We just use suggestive language because, that way we could get what we want, but nobody could trace it back to us. Allegedly, guys, from having conversations with a variety of people. Okay, this is what's being told to me, guys, so that's all I have to go on. All right, 12 VAC 5-590-930, fluoridation. Where practical and feasible, the board may require owners of waterworks to provide artificial fluoridation so as long to bring the fluoride ion concentration to the optimal level set forth. That is what was put into the waterworks regulation, and they changed that in 2021 to recommend. Okay. It says this was not a lawful exercise of delegated authority. It was an ultra vires act. At the time, VDH was already aware that approximately 3.7 million of Virginia's 4.4 million residents were consuming fluoridated water. This is we just covered this a minute ago, but this is very important. So it kind of gets you into the mindset of like, well, why would they want to risk their, careers by sneaking in this waterworks regulation? And here it is again. Dr. Shanholtz stated that Virginia was a leader in the fluoridation of public water supplies, with approximately 3.7 million of its 4.4 million population drinking from a fluoridated supply. VDH had been allowing localities in Virginia to unlawfully contaminate the water for 23 years. They had created a massive problem and they needed a solution. This is in my opinion, guys, from my research and my investigation. This is what I believe happened, okay? I think I've provided the evidence to support my claim, and nobody can tell me otherwise. So if somebody would like to correct me, then please do so. But I keep asking questions and nobody wants to answer it. Nobody wants to take responsibility. So this is what I have to go on. I have to go on reading the meeting minutes and, using a little bit of common sense and reading comprehension. Rather than halt an unauthorized practice, the agency chose to double down by embedding fluoridation into a broader set of waterworks regulations developed in response to the Safe Drinking Water Act. VDH effectively treated the rollout of new waterworks regulations under the Safe Drinking Water Act as their golden ticket, while assembling an extensive regulatory package over a 2-year period. The agency took advantage of the volume and complexity of those rules to quietly insert a fluoridation provision it knew it had no authority to enact. In doing so, VDH relied on the assumption that such an addition would go unnoticed and unchallenged. And we have State Board of Health, May 7th, 1974. It says, summarizing the presentation of his staff, Mr. Adams stated that they had given close consideration to all comments submitted and felt they had been able to accommodate the majority of them. The regulations had been studied and worked on for a period of over 2 years, and he felt the proposal as presented represent a good working. So they had these meetings. They put it in the newspaper, people came out, and Mr. Adams is saying, I think we're good to go. Where was Mr. Adams saying, like, hey guys, we didn't put in the newspaper that we were going to be making a regulation regarding fluoride? Where was Mr. Adams then? Wonder if Mr. Adams is still alive. Okay, so it says here, moreover, the circumstance strongly indicate that VDH failed to comply with required procedural safeguards in adopting this regulation. Having known that it lacked the legal authority to promulgate a fluoridation rule, VDH appears to have bypassed or failed to properly execute the required legal notice of public hearing specific to fluoridation, depriving the public of notice and opportunity to be heard on a matter of significant consequence. This procedural failure further undermines the validity of the regulation and reinforces that its adoption was not only substantively unlawful, but procedurally defect as well. Okay, this is my opinion. The use of permissive language stating that the board may require fluoridation further underscores VDH's knowledge that it lacked the legal authority to mandate such action. Remember, that's where they draw the line. Mr. Adams said, you can't say require, but let's use some manipulative language and say may require. This was a deliberate attempt to create the appearance of regulatory legitimacy where none existed. The lack of statutory authority has never been cured. Accordingly, the fluoridation regulation adopted in 1974 was unlawful at inception and remains unlawful today, in my opinion, based on my research and having conversations with people up and down the line in government. Henrico County is not bound to continue enforcing or relying upon an unlawful and procedural defective regulation. To the contrary, it now has the opportunity and the obligation to correct course and cease participation in a program that lacks clear statutory authorization. Accordingly, Henrico County's reliance on VDH permits as the basis for its fluoridation program is legally insufficient. In the absence of clear statutory authority, the continued addition of fluoride to the public drinking water is ultra-vires and must be immediately ceased. Continued reliance on such invalid authority after receipt of this letter may constitute knowing ultra-vires conduct. I think that is where we should leave it off today, and we will pick up next time on page 28. Okay? All right. Well, that is it for today. So I did go off on a few little tangents here and there. The Village of DeForest, has got me a little bit more spun up. The type of ridiculous things that they were saying last night, really got my goat. It just shows how corrupt our government is and how unethical our government is. More than 95% of the world does not put fluoride in the drinking water because it is a violation of their constitution. It's a violation of their state law. For example, Germany, they don't put fluoride in the drinking water because they say it violates the Nuremberg Code. Number 1 of the Nuremberg Code is free and informed consent. And if you put this chemical drug in the drinking water, you are coercing the public into ingesting the chemical drug, and they have a problem with it. Some countries say that they're not doctors and it's not their place to impose medication on the public. I mean, in any other situation in America, you have to have a court order in order to impose drugs on the public. But no, not Henrico Board of Supervisors. They're going to circumvent the doctor and go ahead and put it in the drinking water. So anyway, that's going to be it for today. I hope you enjoyed the video. Leave a comment below if I got something wrong. Feel free to correct me, and I can update you guys in a later video. So that's it. Make sure to leave a thumbs up, comment below, and share this with others. Okay? Thank you for joining me. Bye, guys.